Thank you for coming. This is going to be billing retainers at IOLTA accounts. Know all the rules. We're with Janet L. Grove from Armstrong, Grove and Warzeneck LLC in Mattoon, Illinois. That's in about Coles County area if you're not familiar. Janet grew up in Bloomington, Indiana and attended Purdue University, where she received her BS and an MS in agriculture education. She got her law degree from Indiana University in Bloomington and practices in the areas of trust and estate planning and administration, guardianships, real estate, business succession planning, and charitable giving. So I'm going to let Janet just take it away here and enjoy the program.
Thank you. Can everybody hear me? Do we know for sure we got them?
Yes, she can hear you.
Okay. I'm happy to talk on this subject. I think this is something about any attorney could speak on because it's something we all need to know, and it's about fees and client trust accounts and retainers. And so today what I thought I'd do is assume that we're going to be, the people listening to this today and in the future online are interested in just a general review, but also some best practices ideas, as well as understanding that some new rules came down last month that are effective this summer as far as our IOLTA accounts, and also the types of retainer fees that are available and the rules regarding each type. So just be aware. So one of the things I'm always interested in is how different attorneys keep up to date on changes in things like the rules of professional conduct. And I had the luxury / hard-earned education of spending 10 years employed as a bank in their trust department. So I learned a little more about the banking aspects. And so I do want to cover those in a little detail that a lot of people are not aware of, not only to educate you and keep you in good standing with your clients, with the ARDC, but also so you understand how banks operate for those of us that handle real estate transactions and things where we are dependent on having available funds, and how that works in regard to protecting yourself and your client from scams. And I have some personal experience there. So let's start in general with fee agreements. Probably the most important thing that has always been the case is to communicate with your clients. And in reviewing the rules of professional conduct, I was surprised that it doesn't require that you notify them in advance, but shortly as upon retaining your services, you need to make sure that there is some written letter. Our office has a form letter. We kind of massage it every once in a while that talks about we are representing you, and my firm does transactional law. So it's estate planning, real estate, estate or trust administration type matters for the most part. And for these services, here's what we're doing. We also address in that letter, when we represent couples, the confidentiality problem that estate planners frequently run into, that one spouse tells you later, hey, I don't want my wife to know that my girlfriend in high school had a baby, or something like that. So that letter is a multi-purpose trouble prevention. It's a tremendous tool if we ever were to get in trouble, and we'd have that in writing in advance. We generally ask our clients, if there are two people, a husband and wife representing, to sign it and send it back so that we have their acknowledged signature that they read it. Well, at least they claim they read it. So just be aware that communication with your client and fully informing them is a big part of staying out of trouble with the ARDC and keeping clients happy. Because of the type of work I do, we have never had contingent fees, and we haven't done much with retainers except in rare occasions. And so our fee is a flat fee. I generally, if I represent a client, usually for just a couple of years during estate planning process, yes, it takes that long, I don't raise the fee, even though my regular fee has increased. I just give them one fee at the time we start in that letter, and then new clients would get any increases later on. Just so you know, all fees are subject to a reasonableness standard. It does not matter if you and your client agree on what is reasonable. If they were to challenge it later on, a court can determine that. One time I had a fee slashed by over 50%, and I was kind of surprised. But what happened was twofold. We did have an error on it that I had missed, my clerk had missed, and the judge caught. And so I think that was just punishment for that. But I also realized that in my neck of the woods down here in Southern Illinois, I do charge a significantly higher fee than most other estate planning attorneys. But I also consider myself, after almost 40 years in practice, having a much more sophisticated tax practice. And I get a lot of feedback even from other attorneys and from CPAs in our area. They're looking for specific tax expertise. And so I'm pretty comfortable with my fees. It's less than they charge further north or to the east and west when you get to the state lines, but reasonableness and fairness are key. So one of the things I want to go over now is the new types of contingent fees that have been set out in this update to the rules of professional conduct. And I think we were providing a link to you to the ARDC website. It's very easy to maneuver if you just go to ardc.gov. But they do have two versions. One is just the rules, but what I have in front of me that I was going to kind of help with my program today is a comparison. The strikeout and the additions are made. So it was a huge change in the types of fee structures. And first of all, we all know about flat fee or fixed fees. Those aren't the same thing. I charge a fixed rate per hour, and I keep track of my time. And I am, over the years, you get pretty good at estimating for clients that it will be between, X and Y. And we keep track of our time. And what I also learned the hard way early on is that I always go pretty far over what I think my high estimate would be, because that way they're always happy when you come in under. If you only tell them one fee, like, oh, I think this will be, $1,500 to do wills and powers of attorney, they remember that. And if for some reason then you get into trust work or something else, they forget that that fee was non-inclusive. So I always give a pretty good range, and they're happy with that. I had a judge tell me one time that when he was in private practice, he gave his clients a choice that they could choose either a flat hourly rate or they could do a flat fee. And he said, in particular with the state administration, almost all of his clients preferred to go with the flat fee. They were just terrified of the hourly rate. And I think that's probably still true today. I haven't offered my clients a choice, but I know that there's a lot of variation among lawyers in how they do charge for these services. Excuse me just a minute. So the types of fees we now have, there are three basic types: the fixed or the flat rate. Then there's the contingent fee. And I think most of you that are in the litigation world are familiar and know how to handle these properly. But the one change that was significantly made this year was the types of retainers. Retainers now are specifically defined in three different types. You've got the what they call the engagement retainers. And I think this is the traditional one. What they call is just a general classic or true retainer, where they give you money. It goes into the client trust account. It does not belong to the attorney. And then periodically you get bills approved by your client, and then you deduct that payment from that classic retainer. We now have security retainers, which I think we've always had. We just didn't necessarily use them, have them by a different name. And these are security payment retainers. Now, these are very different. In fact, in this retainer, the money becomes the attorney's money. It does not go into the client trust account. This is a retainer paid in order for the attorney to reserve time and to remain available to assist the client with a particular matter. And that this fee is the attorney's fee upfront, even if no services are eventually rendered, but just to make sure that the attorney promises that he or she will be available if the need arises at the time the client needs the work done. So again, everything in writing, the details spelled out, is very important. Now, remember that these fees can be refunded in certain circumstances, as can any retainer. The third type of retainer is a special purpose retainer. And I had to read this a couple of times to understand it. But it really is a result of a case, a Supreme Court case that came out, I believe, in 2007. And that case has been included in the rules now. So if you look this up, you'll get all the details. But this is a special purpose where a payment is made to a lawyer, and it is intended by the client to be a present payment to the lawyer in exchange for the commitment to provide legal services in the future. And it is the lawyer's money immediately upon payment, so it does not go into the client trust account. The client must sign this agreement, and it must describe and use the language special purpose retainer. And the thing that I find also interesting is that even then, all fees, regardless of the type, can be subject to refund if they haven't been earned by the attorney. So some of this is a little bit interesting wording, and I think it'll be fleshed out as the cases arise where people are in doubt. But one of the things that needs to be explained is why the special purpose retainer is in the client's best interest. And so I don't have any examples of that. I didn't see any examples in the materials on the ARDC website, but just be aware it's out there. But you can't use your everyday simple, here's my engagement letter and here's how I'm going to charge my fees. I think the special use retainer is for some litigation matter, or it could be a significant business matter that's coming forward or opportunity coming forward. And don't forget, as always, attorneys can get paid in things other than cash. In our area, we had a boom in the 1930s and 40s in the oil and gas and mineral business. And so as attorneys were passing away and I was handling their probate estates, we had a lot of fractional interest in wells that actually produced something or not. But it is interesting to see how attorneys get paid. We've had attorneys get paid with land before. I don't know, maybe it's just our area. They get really creative the further away they get from Chicago. But those are the common and acceptable types of fee arrangements. Now, it's interesting, they said in the rules, common types of fee arrangements, and they list these 5 different arrangements. But the fact that they say these are the common ones, I'm not so sure that there might be some more creativity available out there, whatever comes up. But I am familiar with the security retainers and the engagement retainers, but this special purpose one was new. So if you have any questions, I suggest 2 things. Read the new rules. They will become effective this summer. And always, you can call ARDC. I have called them before when things came up that I was uncomfortable with. And, you know, it's like, who are you going to call? We don't have Ghostbusters, but ARDC is about the next best thing, because they did help with some guidance. They did help me understand a little more of specific portions of the rules. And they could also steer me to some references outside, whether it's case law or things like that, that help. So I encourage you to use their services. They're very helpful. In fact, years ago, I received a call. I served on a committee through the state bar with someone who was on the ARDC employment. And they called me because they had a very unusual case regarding an attorney who drafted a will for someone who wasn't a client. The attorney was hired to draft a will for someone else. And at that time, there was no prohibition in Illinois in the rules for that. And to this day, I don't think there have been. And so we had a long discussion, and I did as much research as I possibly could. And I think some other states do have rules prohibiting that. But in this particular case, so far, we do not. At this time, I'd normally be asking the room that we're in for if anybody had any questions. But since we have one listener, I hope that you will either text in your questions or speak up if you have anything as we go forward. The next thing I want to talk about, and this has been something that I have been surprised how difficult it is in our small town to handle, and that's the IOLTA trust accounts. I don't know if any of you had trouble, but when we started our practice in 1996, we rented an office in a bank building, so we thought we'd just do our banking there. Wouldn't that be convenient? So we proceeded to open up our main account, and then we needed to open 2 trust accounts. One for our general purpose client trust accounts, and then a separate one for real estate, because it is required that real estate matters have their own separate client trust account. And the bank said, sure, we'd be glad to do that. But when we started to dig in, and I noticed that IOLTA never appeared anywhere on the name of the account as it was registered at the bank, I began to realize that I don't think they did have it. So they ended up having to go through ARDC and get registered and become recognized as an acceptable bank. You can only open these at banks that are listed on the ARDC website. And in addition, with the new rules that are effective this summer, two things: overdrafts are now reported directly to the ARDC. And the ARDC will investigate every overdraft, even if the withdrawal was not dishonored, which is something in banking they can do. They can choose a bank for their good clients. Sometimes they'll notify you that this check had insufficient funds, but they went ahead and honored it. And that's to our favor, but the ARDC will still investigate. That's a major breach of fiduciary duty for attorneys. And the whole idea of client trust accounts is to protect clients' money. So make sure you understand all about overdrafts there. And the statistics I looked at the ARDC website for attorney misbehavior, the latest was, of course, 2021. And it was interesting. 70% of all the attorneys that actually had sanctions of some kind, 70% were solo practitioners. I think that's really important for a lot of small firms, small town attorneys to recognize that. For me, the most important thing I could do is my older partner worked his way out of the business, was to find some younger partners, because that is the best protection you can have. And I really appreciate having the younger attorneys with me now to help me with their insights. They've worked at other firms, and it's interesting to put our heads together and try and come up with a really good way to run our office. 51% of the people that were sanctioned, the attorneys, had more than 30 years of practice. And that's kind of sad to me. But the other interesting statistic is that 37% of those sanctioned were located outside the state of Illinois. So I don't know what that says, but in itself, but I do think that older attorneys, solo practitioners, need more help. And this is something I know when I was active in the state bar, that we were working on senior lawyer section counsel and other groups to try and find some support for attorneys who were aging out. And we specifically talked about, as they became signs of aging, tired, poor memory, whatever it is, to try and have a circle around our profession so that there are resources available to help attorneys and firms in that situation. My staff tease me now that, you know, they're helping me more than I know, and I think they're probably right. With the IOLTA account, two things important. The account is not owned by the firm, and we clearly label our account so that the checks that we have specifically say IOLTA, and then it has the name of our firm, probably an abbreviation because we got a long name now. And then we have client trust account number 1 and client trust account RE for real estate, because we have had mistakes made before where they went into the wrong account. And just to make your day a little brighter, one of the things that's changed in the rules is that you now are required to do quarterly reports that you maintain in your office. And so I don't know how other firms are handling their IOLTA accounts. I know with our simple QuickBooks that we use, that we were not able to use IOLTA in with our firm, other than we showed $100 for each account that we had to put in of our own money as the minimum balance to keep the account open. So that shows as an asset in our firm's QuickBooks account. But we set up a separate business with 2 checking accounts, one for each of the IOLTA accounts. And this has worked extremely well because we have all of the information on each deposit and each disbursement from that. And then we can break it down by client and just print out the transactions related to that client. So I think we're going to do everything in the way of bookkeeping required to meet the new requirement, the paper requirements, the accounting transactions, except for the fact that there is now a quarterly 3-way balancing between what you have in your record keeping system in your firm balanced to a bank statement for each IOLTA account. And so we are going to use a form fairly similar to the one provided on the ARDC website, but I'm going to add a place for the person to initial who actually does the balancing. And I want an attorney in our firm to initial it as well. And then we'll scan these and have an e-folder that's just for the ARDC IOLTA accounting reviews. So the forms are all there. They're all available. I couldn't understand them completely looking at them yesterday for the first time, but I think that if you make an effort, and hopefully you are already regularly monitoring all of your IOLTA accounts. We had a partner who passed away last year, and he'd been practicing law for 60 years. So we have some funds in the IOLTA account, and we are trying desperately to find his records. I had already done that when he was still able to help me, so I think we'll be okay. But one of the things that is, again, in the rules of professional conduct is when and how to turn client trust fund money unclaimed, where you've done everything you can to try and get it back to the true owner, or try and even find out who the true owner is. You can submit that to the unclaimed property for the state of Illinois, and there's a process for that too. This time next year, I'll be able to tell you how to do that. With your fees, two things, and your engagement. I hope you all use engagement letters. We didn't for the first couple of years in my practice, but after going to the very first solo and small firm program, that's one of the things we started doing, because it's just cheap insurance, and it does help clients going forward. And we've developed more and more forms in our office. And the joke is when the younger attorneys come in and said, "What about this?" I said, "Well, there's a form for that. There's a form for this. There's a form for everything we do. Form for receipt for abstracts, a form for deposit of client trust fund money." And of course, the accounting systems now for law firms are really good at helping you track client trust money that is on hand in the banks. So, when we first started, we didn't have computers, so we had to do it by hand, but this works really well. If you are not using a software system specifically for attorneys, I would highly recommend it. It has actually saved us time in the long run, just by having some things set up specific to us that we didn't have to customize from various types of businesses. The general rules have not changed for fees, and the big thing is it's got to be reasonable, and there are a number of prohibited types of fees. And these were interesting for me, being a non-litigator, non-matrimonial lawyer. You can't charge a contingent fee based on whether you get the divorce. You cannot, as part of your, let's say you want to take an in-kind payment for some of your fees, you can't get a percentage of the outcome from a litigation matter. And things I'd never thought about in my little practice. You can have other types of fee arrangements. I tend to be hourly, but we're trying to gravitate to more fixed fees. I think clients like it better. And the problem is it takes years to establish a really comfortable feeling for how long things are going to take, and to build into your letter to clients, your initial engagement letter, that here is the scope of my engagement. If we get into other work, I will give you an estimate of what that additional work will cost. Frequently, we'll start doing estate planning and then find out that they do want a trust after all. And so I'm prepared, after my experience, to actually tell them, well, that'll be extra, and approximately how much, although you never know for sure. One of the things we run into also isn't just our fee, but in our line of work, we frequently want to do title work to verify ownership of real estate before we complete estate planning. How can you ever be sure? And so we try to prepare clients for that expense too. We don't always need it, because we have fairly recent title work in some cases. In other cases, they haven't had title work done for generations. And of course, nobody knows where the abstracts are after 50 years or more. But the other thing that I don't know if a lot of attorneys are aware of is that other attorneys who you might consider to be your competitors, especially maybe in transaction law, we help each other. If I need a book, I can call an older law firm in town, and they're more than willing to let some of us get into some of these old books. We don't have to pay to access them online. There was a book I needed recently, And it was going to be $5,000. It's a very sought after book, Scott on Trust. So I was trying desperately to find a free copy. And since I didn't go to U of I Law School, I wasn't going to be allowed to go in there. But we have our connections and we have our ways, and other attorneys were very helpful as I've needed various research, and I'm willing to help as well. And I especially have helped people with tax law questions, state tax and income tax questions. So I hope you would offer your own expertise to other small and rural lawyers, and also maybe seek some help from other attorneys as well. It's just good for business for all of us. And in the end, I believe I've gotten some business out of it because these other attorneys have decided, well, we'll just let Janet do it, because we have plenty of work, So if you have questions about any of this, you can call me at any time. I think that the ARDC does a pretty good job in reviewing. I think they do an excellent job helping you find answers to questions that you don't see off on your own research. And I can tell you also, one of the things that you have to be very careful with your client money. I'm not as worried about in your own bank account, the firm's account, but with client money, I was approached with a real estate deal from an existing client, one of my favorite people. He was delightful to work with. And he had found on Zillow a buyer for his home. And so he wanted to close. They didn't have to pay realtor fees. It was going to be great. They got full asking price. And the theory about two things, red flag was going up, just sounded a little bit too good to be true. But the other thing is I'm old and jaded, and this just didn't pass the smell test. So I had everybody's names. I had copies of the emails back and forth. It was somebody from Spain that was moving to Mattoon, Illinois, that wanted to buy this house. And there were a couple of little things that made me a little uncomfortable. And I told the client, I said, well, let me do some research. I didn't make any promises. I didn't disclose that I had any major discomfort. But the first thing I did when he left was I Googled the buyer's name, just flat out general Google search. And I came up with a whole bunch of hits all over the world for a real estate scam. And let me tell you how it would work. This buyer wanted to sign a contract right away, full asking price, have just a very normal process. And in our neck of the world, this works. It works very well. But the thing that was a little odd is they wanted to wire transfer to my client trust account the entire purchase price, including a little extra to cover their share of expenses. So they were going to send $5,000, about $5,000 above the asking price. And then after I discovered this scam, I went to the SEC website and I talked to a local bank and found out two things. A lot of attorneys are really smart. And I was a smart attorney. I'd worked at a bank, and I know that wire transfers, after 24 hours, they can't be, you can't get them back. And so you can't stop payment on a wire transfer within 24 hours. And I believe that's still the rule today. So you'd think I'd take the wire transfer and then after 24 hours, I'd be safe, right? No. Here's what I found out. Fraud isn't bound by the 24-hour rule on wire transfers. What would have happened is I would have gotten the funds in, we would have had the closing, we would have recorded a deed in the buyer's name. And then several days to 2 weeks or longer later, we would find out that the money was stolen, that was wired to me, was stolen from someone else's account, and they wanted it back from me, not my client, from me. Of course, I would get my client to give me how much he had, but I would probably be out the $5,000 that was not related to the purchase price, the funds that my seller received. So beware, and do not assume that you understand banking laws. They're much more complicated than we think. And in fact, it's such a problem now that the title companies in our area, and probably most areas, are very, very cautious when receiving or transferring wire transfers, because it has been so hard to catch in real estate deals that close very quickly. You get the money and you close very quickly after that. There's no time to track back. But I will tell you, even with local home ownership, we are tightening up when we are dealing with a for sale by owner, which I rarely do, but I will for some clients. If the prospective buyer has to produce a letter from a bank with a pre-commitment, not a pre-approval. We want the bank to have done their due diligence and make sure that these people are legitimate and that they have access to the funds through that bank if the house appraises at the price that at or about what we're asking. I can't urge you strongly enough to know banking rules in dealing with this IOLTA account. There have been many attorneys that have gotten badly burned, not because they did anything wrong, but they just trusted people too much to do business as usual. And you really can't do that with client funds. And I don't know, it seems like I am getting more and more calls at home. We've disconnected our landline. That's helped a lot. And just once you succumb to one, which a lot of my older clients do, then you get a lot of them. And so beware, educate yourself, take advantage of all the CLE you can get. They're usually small bits and pieces like we are today on a very narrow topic, but the banking industry has very specific ones. And if you do any real estate deals, make sure that you know exactly what you're dealing with. And that's probably true in other areas of practice as well that deal with cash coming and going in large sums. The last thing I want to mention about IOLTA accounts that a lot of people do not know is that not all client money needs to go into an IOLTA account. The normal IOLTA account where you have commingled funds among several clients, the interest is earned on that account, but it goes to provide legal services through ARDC. And so it's not the clients that get the interest, but if you have an estate for perhaps, or for some reason, you're going to hold a large sum of money for a little bit longer than a short period of time, that client is owed interest. And so we on occasion have set up a separate client trust account. It is not an IOLTA account. It is a trust account for the benefit of that client. Their name is on it. We use that client's tax ID number to open the account. And it just means that they will get the interest so that when that money is finally paid out to the proper party, that the client gets the interest or whoever would be entitled to it. So do not automatically assume that all of your funds that you're holding for clients go into the same account, one for real estate, one for non-real estate, because it may on occasion need to be in an account for that client. I do appreciate the fact that from my years of banking, before we had interest-bearing client trust accounts, a lot of attorneys would say they don't want interest on that account. It's just too much trouble. So guess what happens? That means the bank was making money off of those accounts, and somebody smart at the ARDC came up with this idea of having the interest paid, but have it go to a good purpose. And most of our client trust money is very short term, even the real estate deals, but just beware, know the rules, and remember to stay current on the rules. It'll be interesting to see what other types of programs come out to help people and help attorneys get up to speed on this new program that is effective this summer. Trying to think, let me see if there's anything here. Let's see. In my years of practice, it seems like ARDC has become a lot more user-friendly on their website. Please take advantage of all of their forms and documents, not that you have to use the exact same ones, but especially for these client trust accounts. I think that they've done a pretty good job spelling it out, but I would still add a place for whoever prepared the reports and the balancing the accounts we do it monthly. But I want the initials of the attorney that looks it over too, because I think that's important. If anyone would ever challenge something or something goes wrong, remember, every overdraft is investigated, even if the bank did not return the withdrawal. And you've got to answer to that. And the best thing you can do is have really good records and show that you caught it quickly and that you caught it within, because a lot of banks say that sometimes banks make mistake. I actually had a bank deposit to the wrong account one time. And if that had caused problems, they only give you 30 days in some cases to get make it their fault for them to correct. And I certainly would like to go in front of ARDC and say it was a bank error. We caught it that end of the month when we did our reconciliation. And so the bank corrected it and paid all expenses that it cost to get it fixed. So you want to be in that position too. I'm assuming everybody's saving files electronically. And do keep in mind, if you are like me and once in a while your firm changes name, gets a new tax ID number, you may need to take extra steps to carry forward your long-term records on your client trust accounts. Now, hopefully you don't keep anybody's money in there more than 7 years. And after 7 years, then send it to the state of Illinois unclaimed property if you haven't truly exhausted all avenues to find out who it belongs to. And then in that regard, I'm kind of amazed. I know some clients who we've written several letters to, and we still never hear back. So I don't know if they have had a health problem, but they still live in the same house. But for whatever reason, they are not stepping forward to claim that little bit of money that we have. And I'm not comfortable signing a check and mailing it to them. So we will have that go to the state unclaimed property at some point before I retire. Communication with clients is your best protection from ever being criticized. And I can tell you, everything goes along fine for a while. You've got your client letter, what I call a client protection letter, where they're protecting you by you disclosed everything. It's fair. They understood it. They understood if there was a conflict between husband and wife. And then if they kind of forget that or get upset with whatever transpires down the road, because you have that letter, ARDC is like, we can't help you. I mean, this attorney did everything they could to keep you informed. And let's see here. We've got, I don't know if you actually want to see the current rules for attorney fees. It's rule 1.5 as amended in March. It's effective July 1. It's 24 pages long, not because it includes the comparison of what they took out, which always helps me understand it a little better. But I think if you were to read the new rules, I think there's a couple of places where there may be questions. I'll be watching to see if ARDC cleans these up, and I may even decide to ask them about that one regarding retainers. There's this blanket statement in here that says non-refundable fees and non-refundable retainers are prohibited. And to me, that's in a little bit of a conflict when you remember that we've got that type of retainer that's an engagement retainer that belongs to the attorney immediately, even if they don't do the work. And I suppose the refund would only be in case the attorney became ill or something happened and the attorney could not or would not do the work. The other thing is, and I don't have an example to give you, but there are retainers explained in a letter to the client that also talk about if you want a refund, here are the steps you go through. The Supreme Court has said that you can't make those steps too difficult or onerous to get through. So I don't think any of us are those kind of attorneys anyway, but the big thing we have to do, I think in all fairness, is protect the client. That's what the Supreme Court's all about. But as business people, we truly have the right to protect ourselves from bad clients, which hasn't happened very much in my line of work, but I know other firms, I'm sure it happens more. I just have really nice clients. I send them someplace else. Just kidding. The hard part, I think, sometimes is estimating your fee when you're on an hourly rate. I've advised my younger partners to strongly come up with a set of flat fees for different services we provide, because it's pretty regular stuff. And you're allowed to have a flat fee for this scope of work, and then you will charge by the hour for doing any extra work that regarded to real estate or trust preparation or whatever it may be. One of the things we don't do in my office, we do not do tax returns. I think that's pretty unusual for estate lawyers. We don't do 706 estate tax returns. We don't do income tax returns for fiduciaries. And as I was taught early on by my older partner, is we have plenty of work. We don't need that kind of liability. And we've made a lot of friends with the accounting firms because we don't do those tax returns, but it has made my life easier, although I have still had to understand a lot about income and estate taxes. The case that is pivotal, I think, with these major changes in the Code of Professional Conduct regarding fees is Dowling v. Chicago Options Associates, Inc. And it had a lot to do with the retainer that the law firm got. And the court opinion went into a lot of detail about fees in general, retainers in particular, and they identified this special purpose retainer apparently in Dowling. And I started reading that case and I still wasn't sure why they used the special. I didn't see that what was in the client's best interest in regard to using the special retainer. So I'm anxious to see one of these days what's going on there. I don't know if you have ever been in a situation where you had a dispute over fees. I have had people that question my fees, and I would say 90% of the time, or 95, I could explain what was going on, although we itemize our bills. But I also have had clients that thought it was significantly higher than they were expecting. And if I don't have documentation that warned them or whatever, I'm pretty generous about cutting it back, because I do think it is important to be fair. And if I did fail to properly describe the scope of work in a way that they could understand, then I'm willing to take a hit on that. Just seems better for me and better for them. And I don't know if you ever get in a situation where you have to hold other property other than cash in the client trust accounts. With estate work, we have people who are executor from out of state, and they come in and they clean out the house. And recently we had a fishing tackle box full of silver coins that were mint condition. And so we rented a safe deposit box at a bank and had the keys in our safekeeping in our office. And sometimes we do that with what we think is expensive jewelry. We actually had same estate. We found a box of gold coins later on. And rather than keep that in our safe, I went to a local CPA's office, because we found it one day when we were just walking through the house, and I didn't want to open it without an independent person present. So we got the CPA involved, went to his office, and they had a vault. So we inventoried it, made a written list, both signed it, and then we kept it in his vault until the beneficiaries from out of state we could get pictures to them, they could see what we had and decide what they wanted to do. So you got to be really smart about this, but do not trust anybody that comes in your office. We had in our office, we rent from a bank, and they included a cleaning service. And we had a safe, and still there just seemed to be, maybe someone had an envelope with several rings in it in their desk drawer. And we started finding things from our office that were in strange places, like a half can of Coke behind a file on the file shelf, or food half eaten that was from our kitchen area that was tucked in somebody's drawer. So we went to the bank and got keys changed, and we trust nobody. So don't be overly secure. Use secure, safe storage for non-cash items as well. We've had instances where we found a lot of bills, $800 or $900, maybe $1,000 in someone's home, and we're probably lucky we found it. But again, we don't put that just in someone's desk drawer. We like to have it in a locked cabinet. And I understand that if we have a fire, you could lose things like this. But in today's world with digital photography, we take pictures, they go in the client files, and that's been very useful. The internet's changed everything, I think. So I'm really sorry. I think that's about all I can tell you about fees, retainers, and the IOLTA accounts. I welcome any calls, any emails from anybody out there that is listening to this that wants more information. Or in fact, if I've said something, that's different from what your experience has been, I take the view that we basically can help each other, and hearing from you helps me in more than one way. So are there any questions? Do we still have one person listening? Do we know?
Yes, we just have Jenna here still. And did you want to show them where to go on the ARD website?
Yes. And do you want to help me learn how to do that? I hit share screen.
I can do it for you. We'll go from there.
Okay, thanks.
Okay, so here is do you want to talk or do you want me to?
I was gonna say, I can't scroll around, so I was looking,
Okay.
I'm having a little trouble seeing all this.
You should be seeing the screen here. So you would go to,
Education and practice resources.
yep, education practice resources, and then client trust accounts. And then on the right here, there's forms and links. You can just click, I've already brought it up, the sample forms.
And I don't want you to laugh at these. I think they're kind of, they look hard. But if you use QuickBooks, you can print out those reports and get about the same place. They basically, and this is what I do whenever I'm in charge of someone's account. I give them a photocopy of the bank statement, and then I give them a photocopy of my accounting from QuickBooks or whatever I'm using. And then I have a handwritten reconciliation of both of those and account for unrecorded deposits or unrecorded withdrawals to show that they balance. And it, so you have your trust account, like we have 2 trust account numbers. And, it's sad that they have to put on here, these amounts must be identical to each other. The client ledger, the trust account journals balance, and the trust account checkbook balancing to the bank statement. So interesting. We did have the other thing that I was going to show them on that same website. If you, let's see if I can get back to that.
Sure. No,
There's an article, and I know it's from 2017, but it's about that Dowling case that goes into more detail. I did not read all of that. And I think the other thing is what happens when you have a negative balance in a trust account. And like I said, they're now requiring that the banks notify the ARDC, and they will investigate every one. I was kind of disappointed. I looked at the email scams and lawyer trust accounts. That's an article on the ARDC website as well. And I thought that they, I don't know, I found better resources like on the SEC site. And I couldn't get into the American Bankers Association. I bet they have a chock full of email scams help you explain. But the big one I worry about is with real estate transactions or anytime you're dealing with wire transfers. And let's see, I mean, and then don't be shy about calling if you are the least bit uncomfortable with any part of accounting for the client funds or reporting. I don't believe that there's any reporting yet. I didn't see any requirement that we report to them. But if there is a problem, they said, like, if you would ever have an overdraft, regardless of whether it was a bank error or somebody else's fault, they will want to see at least 3 prior reconciliations on your client trust account. So make sure you have those. It's always easier to just hit print than to have to go create them because you didn't do them in a timely fashion. And I hope everybody has an office manager that is docketing, every quarter. And for us, it's every month to reconcile the client trust accounts. And let's see. If you're interested, the ARDC has Speakers Bureau, and they don't speak to the general public, but they will come down and speak to groups like a bar association, and they probably do it by Zoom. And I thought that might be really helpful for local bar associations to take advantage of on occasion, especially if you just even want to focus on client trust accounts and scams. Let's see. Trying to see the train the trainer program. I like that too. That's on the ARDC website. And that's where I think maybe for larger firms, they are looking to help train whoever in your firm is going to be responsible for anything to do with ARDC. But in particular, I'm looking at today is the IOLTA accounts and how to manage them. And I don't know about you, but in my free time, like other people look at baseball statistics, I'll be looking at the cases that the ARDC prosecutes, because it is interesting to see how many of them have to do with commingling the attorney's funds with client funds. Imagine this, a client passes away, or excuse me, an attorney passes away. We've had several of them in our little town pass away while they are still practicing law, and they're solo practitioners. No one has any idea what the money is for in their client trust accounts. No one has any idea of any of this stuff. And it's just hard to try and tease that apart. And, you know, I don't know if you know this, but the ARDC has absolutely no sense of humor, none. So great people working there, but don't joke with them. It's like a police officer. No. What else would help? I'm really interested in seeing what attorneys would like to know that they can't easily find out from either this website or from any of the materials. I know that there is a client trust account handbook. I don't think it's been completely updated. I was surprised they even had their new forms on here for keeping track of everything for the reconciliation of the accounts. But ask colleagues, ask ARDC call-in line. It doesn't have to be life or death situation. They'll be glad to help you. So I hope we've helped you some today and kept you awake.
Thank you so much, Janet. I appreciate it. Jenna, did you have any other questions or anything? No? Okay, well then thank you for joining us today and enjoy the rest of your day.
Thank you.
Thank you.